Hi there, my name is Ann Thayer, and I handle a lot of domestic violence cases for both people who are victims of domestic violence and people who are charged with criminal offenses relating to domestic violence. I also handle civil protective orders. That's what they're called here in Virginia. In other states, they may be called restraining orders or no contact orders, and I handle both sides of those cases as well. Today I want to talk to you about protective orders, both from the perspective of somebody petitioning for one and from the perspective of someone who needs to defend a protective order. And I also want to talk to you about how the criminal case can intersect with the civil protective order case if there is a criminal case. That's something that people don't seem to understand sometimes, is that you could have a civil protective order where that's all that there is. You could have a criminal case where that's all that there is, or you could have both. And so today I want to talk to you about what that means. I'm going to start with the criminal case because that's a little bit more simple than the protective order process. To get a criminal domestic assault charge or even just a regular assault charge against someone, you can either go to the magistrate as the victim in the case and obtain a summons or warrant against that person for assault and battery against you if the magistrate finds that there's probable cause, or you can contact police and the police will respond and talk with you. They'll talk to the person accused of assaulting you, and then the police will make a decision whether to arrest somebody based on the evidence that they see and what their observations are there on the scene. If they find that there's been some kind of evidence of a physical dispute, they're going to arrest the aggressor. What surprises people sometimes is that you may be the one that calls the police, and when they come out to the scene, the officer may end up determining that you are the aggressor in the situation and end up placing you under arrest and taking you to the station as opposed to the other person, even if you're the one that called the police. So that's something just to think about when you're calling. You always want to call if you're in trouble and you need assistance. That's what the police are there for. They're there to help you. They're there to protect people, and they want to do the right thing. But sometimes their idea of what's going on in the situation doesn't match up to what really happened or to what you think happened, and it can end up getting you into trouble. The other thing is that there's a big difference in domestic violence cases where it involves a family member or household member or someone that you have kids with than it does if it's somebody that you're not related to and under those circumstances. In a domestic violence situation here in Virginia, the officer, when they come to the scene and they see evidence of some kind of physical struggle or fight, they're going to have to arrest whoever they feel the aggressor is. As opposed to if it's, let's say it's a neighbor situation or an issue at your work or a parking lot fight or something like that. The officers, because they didn't witness anything and because it's not domestic violence, unless there's other witnesses and things like that the police can corroborate to help obtain charges, usually they're going to tell you to go file your own charge with the magistrate, or they'll tell you that you can go file a protective order. So once the criminal case is filed, the person that's arrested is going to be taken to the station. The magistrate will determine what charges to issue. They'll determine whether to release that person on a bond or to hold them. If they release the person on a bond, sometimes they can go home. Sometimes their bond conditions prohibit that. The magistrate will also, anytime there's a assault and battery case, they're going to issue what's called an emergency protective order. That is good for 72 hours from the date that it's issued, and then it expires. That'll have certain conditions on there. Usually it says you can't go home or you can't have contact, that sort of thing. That expires after the 72 hours or however long the magistrate set it for, unless the person goes to the court and files for a protective order, which they have to do separately. Okay, that issues in every type of assault case. It's required under the law. If the magistrate holds you without bond, then you're going to see a judge on the next business day that the court is in session. The judge there will sometimes review your bond and give you one at the arraignment, which is what that hearing is going to be. A lot of times those are done over video. Some judges will not grant bond at that arraignment. They're going to tell you to have your attorney file a bond motion, and then you're going to have an attorney file a motion requesting that the court grant you bond. That's a hearing where the prosecutor gets notice, the court gets notice, and the pretrial division over at the jail will run some records to see where you're living, your ties to the community, your record, things like that, so that when you come back to court, everybody has a little bit more information on whether or not you should have a bond and whether or not, or what those conditions should be. The things that they're looking at to grant a bond, whether it's the magistrate or a judge, or whether you're a danger to yourself or others. And the other thing is whether or not you're a flight risk or a danger of not appearing in court. So those are the two big factors that they're looking at to determine whether or not you should be given bond and if it's safe to let you return, and if they can foreseeably believe that you're going to appear in court and not cause, more issues as the case is pending before the court. Okay? The protective order and the criminal case sometimes don't match up. Sometimes a protective order will say peaceable contact, meaning you can go back home, but contact has to be peaceful. But then the warrant or summons will say no contact. When those things don't match up, you can't have any contact. The one that says no contact is the one that you have to follow unless or until you get that changed by a court. Once it's changed, you can get those conditions to match up, or if they remove that condition completely, then you would be able to go back home or have contact or whatever it is that you're trying to do under the law. Okay? The criminal case will then be set for a trial. Your attorney is going to try to obtain discovery. Most of the jurisdictions now, we can get or view the police reports, the body cam footage if there is any, if there's any audio or video at the scene, or witnesses, all of them. If there's injuries, we get all of that stuff so that your attorney has a chance to talk to you about where we're going to go with your case and how we can defend it, and be prepared to get any evidence that we need for you, whether it's medical issues, witnesses, videos, audio, any of those things. Okay? Once your case is set for trial, either the prosecutor will not proceed on it if they think they don't have enough evidence, or if the victim maybe isn't cooperating, or they will make a plea offer where you can agree to whatever conditions the prosecutor is wanting, or the case is going to go to trial where we plead not guilty and the prosecutor actually has to prove their case. If you win your case, that's it, the case is over. If you lose your case, then we have to figure out what to do about sentencing, and the judge can either convict you and give you suspended jail time and probation or whatever the judge wants to do. They can even give you jail time. In Virginia, it's up to 12 months in jail and a fine of up to $2,500. So it's and or. They can give you any combination of those sentences. Virginia also has a statute that allows the prosecutor and the judge to defer the case out for 2 years. That's what the statute requires, where they don't make a finding of guilt. You're ordered onto probation and to complete a batterer intervention program and any other conditions, like sometimes mental health evaluations, substance abuse evaluations, whatever it is that the court thinks is needed in that particular case. And if you complete everything, follow probation rules, do all the things that the judge asks you to do, and you stay out of trouble, then your case can be dismissed in 2 years. In some jurisdictions like Fairfax, the court sets that on a date and time that you don't have to come back for as long as you've done everything you're supposed to do. If you violate in the meantime, you're probably going to get an order from the court to appear in court to show why you shouldn't be convicted or why you shouldn't get jail time, for not completing what you were supposed to. In other jurisdictions, the court makes you come back for that hearing for the dismissal. So it just depends on which county your case is in as to whether or not that'll get dismissed automatically by the judge if you have done everything, or if you actually have to go back and appear before the judge. Okay, so that's the criminal process. Sometimes there's a protective order running right along with that criminal case. And when there's a protective order running right along with that criminal case, that's a separate hearing. So that means that the person went and applied in the court for a protective order. There's a petition that they have to fill out. A lot of jurisdictions, especially with COVID, went to having everybody do those in writing. Some jurisdictions, they still do it verbally, and as COVID rules start to loosen up, the court will probably end up going back to verbal hearings where they can hear from people directly versus making them fill out the paperwork. Okay, but once you petition for the protective order, a judge will review it that same day and determine, are they going to grant it or are they not going to grant it. If they don't grant the protective order, they're still going to set it out for a hearing 2 weeks out, and they'll have to serve the other person to get them there so that a full hearing can be held, so that for the judge to determine whether a 2-year protective order should be issued. If the judge grants that protective order, you'll get that protective order that day, and whatever conditions are in there, you'll be protected under those things for the next 2 weeks. The case is usually set within 15 days by statute. The one issue that comes up is the protective order is not in effect against the person that you filed it against until they're actually served with it. So if they're continuing to have contact or do anything like that, that's in violation of the order, they can't get in trouble for that until they're actually served with it. Once they're served with it, then any violations that they have after that, that's where they can get a new criminal charge for violating the protective order. And so people don't understand that sometimes. They'll say, hey, I have this protective order, but the person is still contacting me. Why can't the police do anything? The police hands are tied until that person is actually served with it. Once they're served with it, then the person is looking at new criminal charges. So if you're the one that obtained the protective order against somebody, you can't issue any violations or file any reports for violating it until the person's actually been served. If you're the person that's been served with a protective order, you have to make sure that you read that protective order and your bond conditions very, very carefully and make sure that you're not violating. Because if you violate it and a charge is filed against you and you're convicted, you have to serve jail time. The statute does not allow for them to suspend all the time on a protective order violation. So people don't understand that. And it can be something as simple as waving at somebody, commenting on a social media post, having your family member contact the other person, or even something that's not threatening. It doesn't have to be threatening contact to have a violation of a protective order. It also means that if the petitioner is contacting you and you respond, the petitioner is not in trouble for contacting you, but you're going to get in trouble if you respond to them and somebody finds out about it, like the judge or the officer or prosecutor, or if the victim gets mad at you later and then goes and reports it. They're not in trouble. They're not under a court order not to have contact, but you are the second you're served with that protective order. The other thing that's really tricky when there's a criminal case and a protective order, I mentioned this briefly a little bit earlier, is that sometimes the conditions don't match. So you may have gotten arrested that night and on the emergency order it said no contact, or there wasn't any information about contact, and your bond conditions didn't say anything about that. But then the person went and extended the protective order, and there's either now a no contact provision or there's some other conditions that are put into that order. Sometimes those things don't match up and people get confused because one says you can have contact and one says you can't. You have to go with the one that says you can't until that's modified by the court. So just remember that, and if you don't understand, then talk to an attorney before you're having any contacts. You don't have to worry about that, okay? Now let's get into the civil protective order. When someone files a civil protective order in Virginia, they have to show that there was an act of violence, force, or threat that has either caused them bodily injury or that has put them in reasonable apprehension of death, sexual assault, or bodily injury, and that a protective order is needed to protect their safety and their life. That's what they have to prove. It's a preponderance of the evidence standard, which means they just have to show a little bit more than the other side in order for a judge to grant the protective order. I always tell my clients it's like 49.999% to that 50.00001%, right? It's not a very big difference. The judge just needs a little bit more information on the petitioner side to grant that protective order. When the judge is reviewing that information, they're going to listen to whatever the petitioner has to say, hear their evidence, and then you're going to get a chance as the person who was served with the protective order to respond to those things. Once the judge hears the evidence, the judge is going to make the decision whether or not to grant it. If the judge grants that protective order, it can be for up to 2 years. Usually a judge will grant it for 2 years if they're going to grant one. But every once in a while there's circumstances where the judge thinks that one needs to be issued, but it doesn't really need to be for 2 years. Or there's times when petitioners will say, look, I just want it for the 6 months or a year or whatever it is up to that 2 years, and the judge can honor that request as well. When someone petitions for a protective order, they can ask for you to be kept out of their home and let them have exclusive rights to the home. If it's a domestic violence type situation, they can keep the pet. They could be given temporary custody of the kids until the full hearing is heard. They can be ordered, the person served with the protective order can be ordered not to they can be ordered not to turn off the utilities like the water, electric, phones, things like that. You can keep a vehicle if it's either in your name or it's titled jointly in your name with somebody. Pets are something that you can be allowed to keep. You can be ordered to stay away from somebody a certain amount of feet, or just be ordered to have no contact in general. Exceptions can be made to make arrangements for children, or sometimes people don't want all those conditions. They just want a protective order to feel safe, but they'll tell the court, I want a peaceable contact protective order, which means there's no prohibition against somebody contacting or against the person contacting you. It just all has to be peaceful, meaning there can't be any threats to harm property or you or anybody in that person's family. The person petitioning for a protective order also can put their children on there, their other family and household members, and a lot of times if there's other people that live at the home, they'll list the people that fall under those definitions in the protective order as well. So a judge can grant it for that if the appropriate things are proven at court for the judge to do so. There's a lot that goes into a judge weighing out a protective order case, and like I said, it starts with an emergency one. It can escalate to the 2-week, which is what we call a preliminary protective order, and then the final one is called a permanent protective order. It doesn't mean forever. It means for 2 years, up to 2 years, and then that can be extended. There's also certain situations and really violent or more serious cases where a protective order can be ordered for longer than 2 years. All of those things are on a case-by-case basis with the court, and the court will determine that. But a regular protective order is usually in place for up to 2 years if it's granted by the court. Okay, if the petitioner is given her protective order and the person who was served with it has not been served yet, and they go to that 2-week hearing that's 15 days out, then the judge will continue that hearing out for up to 6 months in order to allow time for the person to get served with the protective order. If the person has been served, then when they come to the court for the hearing, the court can either have a hearing that day, the person who was served can ask for a continuance in order to have time to prepare or maybe seek out getting an attorney. If that case is continued based on that request, the court is going to grant a new protective order from that date until whatever the new court date's going to be, so that the person that petitioned is still protected, and that the person asking for the continuance still has to follow those same rules. If the petitioner comes to court and wants a continuance, most judges, and the statute says only the respondent can ask for that. So many judges will not issue a continuance for a petitioner when you come. They expect you to be ready to go, and that's because protective orders take precedence on the docket. They're more serious matters, and you're supposed to be ready and be able to present your evidence to the court because it's to protect your life or protect you from harm. So if you needed a continuance or you really weren't ready, you could do what we call non-suit the case, and then you'd have to refile it at a later time. There are some judges that believe the petitioner can get a continuance. It's just that the protective order may not remain in place. So if you ask for a continuance, they may give you one, but then there's no protective order from that date until the new date. There are other judges that may still grant you a continuance and reissue a protective order until the new date. It all depends on which judge you have, but for the most part, under the statute, it only says respondent may petition for a continuance. Okay. In terms of proving your evidence, you want to make sure that any text messages, Facebook messages, any other social media, photos of injuries, witnesses. Sometimes people write out a lot of different things in those petitions, and there's a lot of evidence that contradicts it. It gets people in trouble, both when I've represented people petitioning for a protective order and when I'm defending people. So I've seen it both ways, and then sometimes there is a lot of evidence to support exactly what's going on. The more evidence that somebody can present to a court to show that yes, injury occurred, yes, this act of violence happened, yes, they're afraid, the more likely a judge is going to grant it. When it's just a he said, she said situation, sometimes the judge doesn't feel that that's enough information to choose one person's word over another, unless the judge just doesn't find somebody to be credible. So the judge is weighing all those things subjectively to determine how are they viewing each person that's testifying and whether they're being honest with the court, whether those facts and circumstances are proven to the court in a way where they really believe they should be issuing that protective order. If the person at the end of the day gets a protective order issued and the respondent isn't happy, they can note an appeal. And once they note that appeal, the protective order will remain in place until there's a new hearing up in the circuit court, which is you either appeal from General District Court or the Juvenile and Domestic Relations District Court. So once that case is appealed, that protective order stays in place, and all the conditions have to be followed unless there's a modification or something like that made pending that new hearing, which can take a little bit of time. Especially lately with COVID, things have taken a little bit longer, even with protective orders taking precedence on the docket. Okay, if the protective order goes to trial and the petitioner loses and the respondent wins, then there is no protective order in place, but the petitioner still has the ability to note an appeal. And when they note that appeal, there won't be a protective order in place pending the new trial. So a new protective order could be issued at the circuit court hearing, but there wouldn't be one that's in place pending that time that it was appealed till the new court date. You have 10 days to note that appeal. It's 10 calendar days, not 10 business days. So you need to make sure that if you are petitioning and you lose, or if you are fighting against a protective order and you lose, that you get that appeal noted timely so that you can preserve that right and have a chance to have your new trial up in circuit court. We call it de novo. So that judge starts from scratch on hearing everything in the case. They're not going to be hearing things that happen down in the lower court unless there's a transcript or something like that that people are saying different things on, and then an attorney or a party in the case may introduce a transcript or statements or witnesses or something that happened at a previous hearing that's in conflict to what's going on at that time. It's really, really important that whether it's a criminal case or a civil protective order, that if you're charged with those things or you're served with a protective order, that you contact an attorney immediately to find out what's going on. You want to make sure you're following the rules properly. You want to make sure you don't miss any court dates. And then if you can, you want to hire an attorney to go with you to court. In the criminal cases, if you financially need assistance, you can ask the court to appoint an attorney for you because you're possibly facing a jail sentence. In a civil protective order case, there is nobody there to be appointed for you. And so that kind of case, you may be on your own, or you may have to hire your own attorney. For petitioners, when there's a criminal domestic violence case, the prosecutor is on your case and will be the one trying to prepare the evidence and present the case to the court. They're not technically your attorney, you're one of their witnesses, but they're going to work with you, the victim's witness advocates and the officers, to do what you're looking to have happen in a case and to make sure you're safe and protected. Not every prosecutor will do what you want to have happen, but they'll at least talk to you to hear what you want, and then they'll make a decision. Can they prove this case? Maybe you don't want jail, but they want the person to have jail. Maybe you're looking for jail, but the prosecutor doesn't think that that's an appropriate case, and they're going to make some plea offer that doesn't have a jail time situation. So a prosecutor is there to kind of talk to you and get your perspective on what happened and what you want to see happen. But at the end of the day, the decision's going to be up to them as to how they proceed and whether they extend an offer or whether they drop a case, or whether they say, I'm not going to make any offers in this, leaving it up to the defendant to either plead guilty or to go to trial if they don't want to take a plea agreement or if there's no plea agreement offered. In the protective order case, you're the person that petitioned, so you have the sole say in whether or not you want to go forward, if you want to drop it, if you want to work out an agreement with the other side to deal with the protective order. There's a lot of things that can be done on the protective order side that you alone have a say in, as opposed to the criminal side where the prosecutor is going to have the ultimate say in how the case goes forward, and then a judge will make a ruling on those things, and the defense has a say in whether they want to take agreements or go to trial and decide from there. Make sure that whichever side you're on, that you have, the other thing I was going to tell you, was that if you're a petitioner in a protective order and you can't afford an attorney, there are organizations like Legal Services of Northern Virginia, where in domestic violence situations and intimate partner and dating and things like that, they oftentimes will be able to help you. You can fill out their paperwork to see if you qualify financially, and if you do, they will help you with the protective order hearing so that you are represented. There's nothing comparable on the other side for somebody that doesn't have money that's served with a protective order. And then, so it's kind of back and forth. In the protective order case, if you don't have the funds to hire and you're indigent, then you might be able to get some help from a service like Legal Services of Northern Virginia, whereas the person getting served with the protective order has no options for that. In a criminal case, there's nobody really truly representing the victim unless you have your own lawyer to fight for your interests and what you want to have happen. But in a criminal case, that person's entitled to an attorney, and if they can't hire one, then the court will appoint one for them. So it's a little bit of a flip-flop. If you ever have any questions about protective orders, about criminal cases, whether you're a victim, a complaining witness, a family member, person that served with a protective order, or a defendant that served with a criminal case, please know that I handle all of these types of cases throughout Northern Virginia. I'm going on 17 years of doing these sorts of cases, and I'm happy to talk to you. I offer a free consultation My consultation isn't just, oh, pay me and then we'll go from there. My consultations really talk to you about what's going on. I try to get an understanding of what the situation is, what you're looking to have happen, and then I give you a quote based on like what I think I can do to help, and you can decide from there what you want to do. But the main part of the consult, or the point of the consultation, is to make sure that you get your questions answered, that if you're looking to hire me, that I explain to you how that works, get you out a written retainer so that you can take a look at it and know what that means, and how to get that back to me, and what I'm going to expect from you throughout the course of representation, and what you can expect from me. A lot of times there's things I need you to do, like get me the evidence, the witnesses, things like that. I can do a lot of things in your case, but I can't do things like that if you don't get it to me. So I will tell you, I need these amount of things, I need them by these dates, and then we'll go from there. I also will have video or phone appointments with you. I answer emails, I answer texts, everybody gets my cell phone number. So that's sort of how it's going to work if you were to hire me on one of these types of cases, whether you're the person charged or whether you're the person that's the alleged victim in the case. So I hope that answers some questions on protective order cases and criminal cases, and when they kind of intersect a little bit, or even when they're separate. And if you ever have any other questions, just let me know or put them in the comments below. Have a great day.